Article 324 to Article 329 of Indian Constitution deals with the election. It is a very important topic because of many reasons. The first reason is India is a democratic state, and democracy is mentioned under the preamble of the Constitution. And what the preamble of the Indian Constitution says at the commencement of the Constitution is India, we the people of India solemnly resolve to constitute India into a sovereign democratic republic. And after 42nd Amendment in 1976, we incorporated two more provisions in the preamble of the Constitution, and they are the socialism and the secularism. Therefore, now what the preamble of the Indian Constitution says, India is a sovereign, socialist, secular, democratic republic. So democracy is a very important concept which is derived from the Indian Constitution. So this democracy, because the Constitution doesn't define the term democracy. The Constitution doesn't define the democracy anywhere in the Constitution, even in Article 366 of the Constitution, because Article 366 of the Constitution deals with the interpretation clause, but at the same time, the term democracy is not defined in Article 366 of the Indian Constitution. But there is many definition of democracy, but a classical definition is came from the President of United States of America, Abraham Lincoln, who delivered a small speech that speech was he delivered that speech. That speech is popularly known as Gettysburg Address, which is available online, where he clearly defined what is the meaning of democracy. So I will share that small video in your WhatsApp group. But very important thing is, as far as India is concerned, even though the term democracy is not defined under the Indian Constitution, in Keshavananda Bharati versus State of Kerala, the Honorable Supreme Court held that all the provisions contained in the preamble of the Indian Constitution are the basic structure of Indian Constitution. And also in Indira Nehru Gandhi versus Raj Narayan, and the Honorable Supreme Court held that the democracy is one of the basic structure of Indian Constitution. And it was repeated by the Honorable Supreme Court in number of judgments, including the S.R. Bomme versus Union of India. So we are the largest democratic country in the world under the largest written constitutional law. So this is the real concept of democracy, because democracy means right to vote and right to representation. So these are the two important concepts which are there in the democracy, that is right to vote and right to representation. In this regard, this institution, the Election Commission, is a very important institution as far as Indian democracy is concerned, which is mentioned under Article 324 to Article 329 of the Constitution, where Article 324 of the Constitution saying about what is actually the Election Commission and what is actually the function of the Election Commission. And as far as Article 324 is concerned, there is an election commission, and that election commission is called Central Election Commission. And the main function of the election commission is to superintend direction and control and preparation of the electoral roll, and to conduct all elections to Parliament. Parliament means, the meaning of the Parliament, which is mentioned under Article 79 of the Constitution, which includes the President. Parliament includes President, Council of State, and House of the People, and Rajya Sabha and Lok Sabha. and also to the legislature of every state, which includes the legislative assembly and legislative council. So, and also the election of the president and vice president. So, this is the most important function of the election commission as mentioned under Article 324 of the Constitution. Because all these institutions are democratic institutions, and the members of the institutions are elected directly and indirectly by the election commission. And this has been mentioned under different parts of the Constitution, especially Part 5 and Part 6 of the Constitution. Because Part 5 of the Part 5 deals with Part 5 deals with the union, and Part 6 deals with the state. So this is a very important thing: the election of the president, vice president, and parliament and state legislature. So, what about the appointment of election commission and chief election commissioner and such other number of other election commissioners? They are appointed by the president, and the very point is a very important point, that they are appointed by the president after consultation with the council of ministers, because that consultation is an essential requirement under Article 74 of the Constitution. പക്ഷേ ഇവിടെ ഒരു ഡിഫറൻസ് ഉണ്ട്. ദാറ്റ് ഈസ് ചീഫ് ഇലക്ഷൻ കമ്മീഷണർ ഈസ് അപ്പോയിന്റഡ് ബൈ ദ പ്രസിഡന്റ് ആഫ്റ്റർ കൺസൾട്ടേഷൻ വിത്ത് ദി കൗൺസിൽ ഓഫ് മിനിസ്റ്റേഴ്സ്. But as far as the other election commissioners, the regional commissioners are concerned, and the regional commissioners are concerned, they are also appointed by the president, but consultation with the chief election commissioner. അപ്പോൾ ഇതാണ് ഇവിടെ നമ്മൾ ഓർത്തിരിക്കേണ്ട പോയിന്റ്. ഇതിൽ വേറൊരു പോയിന്റ് എന്ന് വെച്ച് കഴിഞ്ഞാൽ, ഇറ്റ് ഈസ് 100% ഇൻഡിപെൻഡന്റ് ഇൻസ്റ്റിറ്റ്യൂഷൻ അക്കോർഡിംഗ് ടു ദ ഇന്ത്യൻ കോൺസ്റ്റിറ്റ്യൂഷൻ. അതെങ്ങനെയാണ് നമുക്ക് മനസ്സിലാക്കാൻ പറ്റുന്ന വെച്ച് കഴിഞ്ഞാല്, in the case of the appointment of the election commission and the functioning of the election commission and the mode of removal of election commission, three things: the appointment of election commission, the functioning of election commission, and the mode of removal of the election commissioners, including the chief election commissioner. So അതിൽ എന്തൊക്കെയാണ്, എങ്ങനെയാണ് നമുക്ക് നോക്കാം. The chief election commissioner shall not be removed from his office except in like manners and on the like grounds as a judge of the Supreme Court. Very important thing. So the doctrine of pleasure is a very important concept which has been mentioned under Article 310 of the Constitution. Which is a Anglo-Saxon concept which has incorporated in our legal system, because we are actually following the Anglo-Saxon legal system, which is fundamentally the major source of Indian legal system. So you know the doctrine of pleasure, which is mentioned under Article 310 of the Constitution. But certain institutions are concerned, they are not working under the pleasure of the appointment authorities. Some institutions are concerned, they are working under the pleasure of the authorities, like Council of Ministers, the Governor of the State, the Attorney General of India, and Advocate General of India. So these institutions, and also all public servants, so they are working under the pleasure of the appointing authority, that may be sometimes the president or the governor or the government. But this doctrine of pleasure is not applicable in case of certain constitutional institutions, especially the election commission, one of the institutions where the doctrine of pleasure is not applicable is the election commission. And the other institution where the doctrine of pleasure is not applicable are the Supreme Court and the High Court judges, and also the Controller and Auditor General. That is the reason why see the method of removal. The the Chief Election Commissioner is only removed from his office by the President on the ground of removal of a judge of the Supreme Court. And you know that ground of removal of a judge of the Supreme Court, as mentioned under Article 124 clause 4 of the Constitution, where it is clearly mentioned that under Article 124 clause 4 of the Constitution that the grounds are proved misbehavior and incapacity. So only on that ground a judge, a chief election commissioner can be removed. And the other election commissioners are concerned, they can be only removed by the president only on the recommendation of the chief election commissioner and not on the recommendation of the council of ministers. So that is also very important thing where we can see the absolute 100% autonomy and independence in the functioning of the election commission. So this is also a very important article, Article 325, where it is mentioned the fact that the electoral roll, no person to be eligible for inclusion or claim to be included in a special electoral roll on the ground of religion, race, and caste or sex. So this is a very important article which prohibit discriminations. ഇതെന്തിന്റെ കാര്യത്തിലാണ് ഡിസ്ക്രിമിനേഷൻ പ്രൊഹിബിറ്റ് ചെയ്യുന്നതെന്ന് വെച്ച് കഴിഞ്ഞാൽ ഈ ഇലക്ടറൽ റോളിന്റെ പ്രിപ്പറേഷന്റെ കാര്യത്തിലാണ്. സോ യു നോ ഈവൻ ഇൻ അമേരിക്ക ആൻഡ് UK ഇലക്ഷനിൽ സ്ത്രീകൾക്ക് വോട്ട് ചെയ്യാൻ കഴിയില്ലായിരുന്നു. അപ്പോ അറ്റ് ദ ബിഗിനിങ് ആദ്യത്തെ കോൺസ്റ്റിറ്റ്യൂഷൻ വന്ന സമയത്ത് അല്ലെങ്കിൽ അവിടെ സ്ത്രീകൾക്ക് വോട്ടവകാശമില്ലായിരുന്നു. ബട്ട് this provision is a very important provision where here in India, as far as the democratic right is concerned, where we never see any discrimination on the basis of religion, race, caste, and sex. And then electoral roll is prepared. While electoral roll is prepared, any kind of discrimination which is mentioned under Article 325 is not permitted. So because you know before independence we were conducted election on the basis of the Government of India Act of 1935, where we can see a electoral roll, a communal electoral roll. But after independence there is no provision for communal separate or special representation. So that is also a very important point. So നമ്മുടെ ഇൻഡിപെൻഡൻസിന് ശേഷം അങ്ങനെ ഒരു ഡിസ്ക്രിമിനേഷൻ ഇല്ല. ഹിന്ദുസിന് സെപ്പറേറ്റ് ഇലക്ടറൽ റോൾ ഇല്ല, ക്രിസ്ത്യൻസിന് സെപ്പറേറ്റ് ഇലക്ടറൽ റോൾ ഇല്ല. ഒറ്റ ഒരു ഇലക്ടറൽ റോളേ ഉള്ളൂ. അതില് ഹിന്ദുസും ക്രിസ്ത്യൻസും മുസ്ലിംസും എല്ലാവരും വരുന്ന ഇലക്ടറൽ റോളാണ്. അത് അവരുടെ വീടുകളുടെ അടിസ്ഥാനത്തിലാണ് അത് ഇപ്പോൾ എടുത്തുകൊണ്ടിരിക്കുന്നത്. So we have no communal electoral roll in India, which is basically one of the most important concept of secularism, which is very important, because in some those countries which are not secular, we can see religious favoritism while in the democratic process, even in the democratic process. So in India, no person shall be ineligible for inclusion of any such role or claim to be included in any special electoral roll for any such constituency on the ground only of religion, race, caste, sex, or any of them. So you please note these 4 important points: religion, race, caste, sex, or any of them. So what are the qualifications? I already mentioned the fact that this democratic right means right to vote and right to representation. And in a frame, then the question is whether the right to vote and right to representation is a civil right or a fundamental right or a human right, or it is a statutory right, or it is a constitutional right. So there is a difference between a constitutional right and a fundamental right. There is a difference between a human rights and a constitutional right. Human rights means those rights which are mentioned under Part 3 of the Constitution or Part 4 of the Constitution. but at the same time, those rights which are in the Constitution, all rights which are in the Constitution are not human rights. In that sense, this is one of the right to vote and right to representation, which has been mentioned in the other part of the Constitution, where it is specifically mentioned. And in Punnuswamy versus returning officer, Namakkal constituency, that case is a very important case. So in this Punnuswamy's case, the Honorable Supreme Court held that the right to vote or to stand as a candidate for election is not a civil right, but is actually provided in a statute or a special law, and it must be subject to the limitations imposed by the law. So that is one of the major reason why right to vote is based on it shall be on the basis of adult suffrage. So that is also a very important point, which means there are some qualifications which are mentioned under the Act, and which are mentioned under the Act, and also some qualifications are mentioned in the constitutional law. So what is actually the qualification as mentioned in the Constitutional Law of India is he shall be a citizen of India and not less than 18 years of age. Before 61st Amendment, it was 21 years of age, but after 61st Amendment, the age was reduced to 18. So these are the qualification which has been mentioned under Article 326 of the Constitution, and that includes a citizen of India and attained the age of 18, and he should not be disqualified by law, because on the basis of certain specific ground mentioned in the Article 326, the competent legislature or the appropriate legislatures may by law impose some certain disqualifications on the ground of non-residence, unsoundness of mind, crime, corruption, or illegal practices. So that is also an important thing, which has been imposed by the appropriate legislature, the parliament and the state legislature through the Representation of People's Act, especially the parliament under the provisions of the Representation of People's Act of 1951 and the Representation of People's Act of 1952. So the next point is this is also the lawmaking power of the parliament with respect to the election is concerned. Election of the parliament and the state legislatures are concerned. And this is on the basis of this particular article, Article 327, the Indian Parliament enacted so many legislations, including the Right to Representation Act. So this is mentioned under Article 327 of the Constitution, and the another important power of the state legislatures are mentioned under Article 328, because this power is a subsidiary power, because it is specifically mentioning the fact that subject to the provisions of the Constitution and also any other provisions of the law made by the Parliament. And the legislature of state may from time to time by law make provision with respect to all matters relating or connection with the election to the house or either house of the legislature of the state. So this is so Article 327 deals with the lawmaking power of the parliament on election matters, and Article 328 deals with the lawmaking power of the state legislatures on election matters. So this power is a subsidiary power while considering the earlier provision, Article 327. And duration duration 6 years or 65 years, whichever is earlier. Duration. അതില് വേറൊരു പോയിന്റും കൂടെ ഉള്ളത് ഇതിലാ വരുന്നതാണ് 6 years or 65 years. ആൻഡ് ഓൾസോ നമുക്കൊരു മൾട്ടി മെമ്പർ ഇലക്ഷൻ കമ്മീഷൻ ആണുള്ളത്. വി ഡു ഹാവ് മൾട്ടി മെമ്പർ ഇലക്ഷൻ കമ്മീഷൻ, ബട്ട് ബിഫോർ 1989 we had only a single member election commission, but now we have a multi member election commission. So that is also a very important point, where the duration is 6 years or 65 years, whichever was earlier. Then Article 329. Article 329 എന്താ പറഞ്ഞിട്ടുള്ളതെന്ന് വെച്ച് കഴിഞ്ഞാൽ, which is a very important point, and which imposes a bar to interfere by courts in electoral matters. So there are two important concepts which are there in this particular article, which saying that the delimitation, so the validity of any law relating to delimitation of constituencies, which is very important, and the allotment of seats to such constituencies. But you know the meaning of delimitation of constituencies. And we do enacted a lot of legislation for delimitation of constituencies and allotment of seats of such constituencies, and which is made by the parliament and which is made by the state legislatures, and it shall not be called in question in any court. So what this particular article says, the ordinary court of the land will have no jurisdiction, which is very important, no jurisdiction, and that any question relating to an election can be agitated only by an election petition that is mentioned in the second paragraph after the completion of the election process. And so this article imposes a limitation on judicial decision making on election matters. So this article imposes a limitation on judicial decision making on election matters. So you know the difference between the limitation on judicial decision making and judicial self-restraint that you already learn in your judicial process. So this article is a fine example of limitation on judicial decision making, where it is specifically mentioned that the ordinary court of the land will have no jurisdiction on those specific matters mentioned in Article 329 of the Constitution. And election can only be questioned by way of an election petition. And it is only presented through an election petition presented to such authorities. Such authorities is also very important. Such authority means, as you know, that the jurisdiction since 1966, the jurisdiction is vested in the hands of the High Court. The original jurisdiction is vested in the hands of the High Court. പക്ഷേ അതിൽ ഒരു കാര്യത്തിൽ the original jurisdiction is vested in the hands of the Supreme Court under Article 71 of the Constitution, because any dispute relating to the president, election of the president and vice president, and then the original jurisdiction is vested in the hands of the Supreme Court as mentioned under Article 71 of the Constitution, as you know the relevancy of Article 71. Otherwise, in all matters relating to election, the original jurisdiction is vested in the hands of the High Court, and then the appeal will lie before the Supreme Court. That was the position. But this particular article specifically mentioning the fact that it should be the election petition should be presented before such authority. Such authority means, you know, Article 323B, Article 323B, Article 323A, and Article 323B, which has incorporated in our constitutional law in the 42nd Amendment, which deals with the administrative tribunal for service matters and administrative tribunal for other matters. So in the administrative tribunal, Constitution of Administrative Tribunal for Other Matters, which has been mentioned under Article 323B of the Constitution, which has incorporated in 1976 in the 42nd Amendment, and after that the appropriate authority whereby a person can file a election petition in respect of the dispute regarding the election of some specific democratic institutions like parliament and state legislatures lies to the election tribunal. But Article 323B, clause D, saying that which exclude the jurisdiction of the High Court and exclude the jurisdiction of not only High Court but all courts except the Supreme Court. So in the Chandrakumar versus Union of India case, that case, as you know, that in Chandrakumar versus Union of India case was reported in 1995. In that case, the Honorable Supreme Court held that the judicial review and independence of judiciary is one of the basic structure of Indian Constitution, where the court held that that provision, Article 323B clause D, was unconstitutional. And after that, the election petition will lie before the election tribunal, then appeal will lie before the High Court, or the High Court can also exercise the jurisdiction under Article 226 or Article 227. And then the second appeal will lie before the Supreme Court of India under Article 132 or Article 136 of the Constitution. So, so this is a very important provision, and these are the books I have referred, and first one is the Introduction to the Constitution of India, Brij Kishore Sharma. എനിക്ക് തോന്നുന്നു ആ ബുക്ക് അധികം അവൈലബിൾ ആവാൻ സാധ്യതയില്ല. അതൊരു old edition, but that book is a very fine book, very good book, very useful book, and which is published by Eastern Law House. And two other books are available: India's Constitution, Origin and Evolution, which has 9 volumes, and which is published by LexisNexis, and the third one is a workbook on Constitutional Law of India, D.D. Basu's workbook on Constitutional Law of India, which is also published by LexisNexis. അങ്ങനെ നോക്കുമ്പോൾ നമുക്ക് ഇത് മനസ്സിലാവും. See, 80 Article 80 is what about the composition of the Council of composition of the